Hi everybody, thanks for coming to the presentation. Today we're going to talk about estate planning and living trusts. What is an estate? How do you plan for it? And the goal today is for you to understand the 5 basic ways that we plan for these things, what estate planning is, and to give you an idea of what you need to do to protect yourself and your family. So what is an estate? Essentially, an estate is everything that you own that has value. You have an estate while you're alive, we just don't treat it that way until you pass away. It really becomes important because when you pass away, these things are left behind and they're kind of ownerless, right? Because you're no longer alive and we need to do something to make them have an owner who is alive. This covers your house, your checkbooks, your bank accounts, your stocks, your bonds, your IRA, your jewelry, your clothing, your cars, your insurance policies, all of those things that we kind of accumulate in life become our estate. So why should you do estate planning? Well, after your death, you kind of want to control who receives what assets. Now, like we talked about before, we don't want property to not have an owner. So when you pass away, we've got to put it somewhere, and either you can decide where it goes or the state will. And if you do estate planning, then you can kind of control and minimize the legal fees associated with these things, the taxes, the expense, and the time if you make a plan for yourself rather than the state's plan. Because everybody has an estate plan. The state has one for you, but it usually involves going through some court procedures and things that will cost you a lot more money than it would be if you made the plan for yourself. Also, you need to think about what happens at incapacity, okay? Let's think about, you can't make decisions for yourself. Maybe you've gotten Alzheimer's. Maybe something else has happened to you. Maybe you had a car accident. You can't make decisions for yourself just temporarily. We need to have someone be able to control your assets and make your medical decisions for you. And if you don't plan for that as well, then, we have to then take care of your estate while you're alive until you're able to do so. So who needs an estate plan? Obviously, the older couples need an estate plan because, unfortunately, when you get older, you get a little bit closer to death, and you've got to look at those things and what might happen when you die because you're getting into your senior years. Then, think about those people with families. Even if you're a younger couple and you've got a family, those younger children may need to be taken care of. Your older children might need to be taken care of a little bit later too because maybe you have a family business or something involved. You need to have those things kind of move and function and be able to continue without you. And then even people who are single and don't have families and are younger need to have at least a base level estate plan because while they may not have millions of dollars yet, they do need to plan for what happens if they get into a car accident or things of that nature, especially once they start to accumulate some assets like a car and a house. Those things don't just automatically go somewhere when you die. There's going to be a probate and things if you don't plan for them. So let's look at a couple of estate plans of some famous folks and kind of how they went. One of the classic ones to kind of show you is Elvis Presley because when he died, he had a little over $10 million. It's a lot of money. It's not as much money now as it was back then. Back then it was really a lot of money. But kind of look what happened. He did have a will, so he did at least do some estate planning. But when he passed away, the first thing that had to happen was they had to pay off his debts. Let's shy of $4 million for that. Look at the legal fees and executor fees. What it took to manage that estate because it was under a will, about $1.9 million. And then, of course, the government gets their estate taxes. Today, estate taxes are a little different than back then. Those are kind of moving targets. We're not really going to cover estate taxes here. We do have a different presentation that kind of covers those. It's a little beyond the basics, but there were taxes here for Mr. Presley. So he died with $10.1 million. Less than $1 million went to his heirs because of how his estate plan was structured, the debts, the taxes, and the fees. The next person we're going to look at is Groucho Marx. Some folks might remember this person, some folks might not. But suffice it to say, if you don't remember Groucho Marx, his mind started to go. He started getting more and more eccentric and do these crazy things, and he got to where he was too sick really to take care of his own affairs. So he didn't have any kind of plan for that. You really couldn't do much planning for that back then. So what happened to Groucho? They had to go to court. They had to declare him incompetent. Yeah, that's right. If someone else has to come in and take care of you because you haven't made these designations, the court has to give that person rights by taking rights away from you and declaring you incompetent. That happened with Groucho. He lost control of his assets, couldn't make his own personal decisions. There was no privacy. When this happens, there's a court file, and the court has to make sure you're taken care of. So what does the court do? The court puts all of your assets, whether it's your house, your businesses and things, on a list. They inventory your income, whether it's a pension and everything else. They put it on this public file where anyone can basically go look at a lot of these things. And every time money's spent for you, it has to be accounted for. So they can go to see what you own. They can see everything you spent it on. They can see where you live, because you don't really have those kinds of privacy things. And it's very costly, because you're going to have to pay this professional potentially to do this. A family member won't get paid, but there's still lawyers' fees because you're dealing with the court, and you got to have lawyers and professionals compile all of these accountings and things. One that's closer to home, Prince. As of this recording in April 2019, this thing's been going on for 3 years. He had no will, no trust. He had hundreds of millions of dollars, did no estate plan whatsoever. So now he's stuck with the estate plan the state has for him. And with that, 3 years in, the heirs have got nothing. But the lawyers still billed $10 million in fees. Even the government hasn't been paid. His estate tax rate is 56%. Hundreds of millions of dollars are going to go to the government, because he didn't plan for estate taxes, didn't plan for his estate, and the total administrative cost, that includes that $10 million there. We're talking about executors, appraisers, those kinds of things come together, is $45 million. 3 years in, the government hasn't been paid, the heirs haven't been paid, and $45 million have already been paid to the lawyers and the administrators. That's what can happen if you don't have a plan. So when should you plan? Right now. You plan while you can, before you need it. You don't prepare for the storm after it comes. You can't fix your leaky roof while it's raining. You never know when something's going to happen to you. You don't need maybe to have the elaborate plan when you're younger and things, but you got to have at least that plan of where things should go and who's going to take care of me. There's not a second chance. Once something happens to you and you die, obviously you can't sign documents. Once something happens to you and you become incapacitated and unable to make those decisions for yourself, you don't have the ability to sign these documents. Remember, you have to be of sound mind and body. Everything has to be ready to go there. So what are the common estate plans? There's the will. There's doing nothing, like Prince did. There's joint ownership, where you hold things jointly, and if you die, that joint person takes over. There's giving assets away and doing that before you die. There's putting a beneficiary designation on things that can, and we know that's your pay on death for your bank account, your beneficiary for your life insurance, and then there's the revocable living. So the first plan, let's look at a will. It expresses your wishes. It's signed by 2 witnesses, and you kind of put out in there everything that you want things to go, whether it's grandma's brooch, whether it's your jewelry, whether it's your money. You can kind of put where everything's going to go. It only controls the assets that are titled in your name. That's important. If it's titled in the name of a trust or something else, it will not be controlled by this. If you put a beneficiary designation on it, it will not go through your will. It will go through the beneficiary designation. These are enforced by the court, by probate court. So what's probate? Probate's this legal process where we go and say, hey, you got a will, it's valid, so we'll respect it. Or you don't have a will, so now we have to do something with your assets. We have to pay your debt, and we have to distribute your assets. Inside probate, that's that process where we say, hey, the owner's not existent anymore, and everything has to have an owner. The owner has passed. We won't have property that's not owned by someone. So this legal process of probate is going to transfer the assets to a new title. And first, of course, you got to pay your debts and things of that nature and your last illness, but then they'll be distributed. It's the only legal way to change title on assets that don't have beneficiary designations that are owned by you. Let's look at how this kind of goes. Think of probate as this funnel. Everything kind of goes in there, right? And when they go through probate, look where the money comes out. Taxes, fees to the courts and things. And then what comes out to your heirs. It's going to be a lot less than you thought coming out to your heirs when you choose probate a lot of times. For smaller estates where people don't have a lot of things, probate can be pretty quick. And a lot of times we do plan to avoid probate, but sometimes we want to trigger a probate. There could be reasons why that goes. So don't think of probate as just this 100% bad thing. Sometimes we do need a court to help us out determining title and things, but most people want to avoid it. It's pretty easy to avoid. Probate's also big business. Yearly, according to an AARP survey, about $1.5 billion go to attorneys every year for probate. Millions go to bonding companies, appraisers, and the probate's average time is between 9 months and 2 years if it's anything but the smallest estate probate. That's a significant amount of time. Like we said, probate's also public. There's a court file with everything in there. Your will can be read by everybody once it's probated. Pretty easy to contest. You just go grab a lawyer, jump into probate court, and go. But once probate starts, it's got the control. It will determine how your will is interpreted. We'll look at those rules and we'll count every comma and every and that's how things are going to go. It's costly. It takes time, and you don't have your privacy. So that's kind of the summary of probate. Wills also don't cover your incapacity, okay? Wills are no help. Wills only come into effect when you die, okay? So it also is expensive. You know, we talk about the time consuming being public, but remember, it doesn't replace probate. Probate must happen. When you choose a will, there will be probate. And with just a will, there can be that living probate we talked about, like Groucho Marx had. And it has all those same kinds of concerns onto it. The way you kind of plan for this is you at least have a durable power of attorney and a healthcare directive. That power of attorney lets someone, when you can't make those decisions, it lets someone make your financial decisions for you without the need of the court. And then that healthcare directive lets someone else make your medical decisions for you without having to get you a guardian. So that's kind of what you want to deal with. If you have a will, you need to at least have a durable power of attorney and at least have a healthcare directive to avoid living. Now, talking about minor children, okay? The court's going to appoint a guardian. That guardian's going to control that kid's finances. That's what happens anytime you kind of give those out. When you give it directly to children, there's going to be the Uniform Gift to Minors Act that's going to have that custodian there that's going to do that as well for the money, and that has costly fees on things as well. The child's going to inherit everything at the legal age. That custodian, that guardian's no longer going to have control of it, and the child comes into their own. Would you want your child getting a hold of $500,000, $3-4 million at the age of 18? That's what happens when you just have a will with your minor children. All right. So the second type of plan, you just do nothing like Prince did. Okay, at death, we're going to have a probate. The assets are going to be distributed according to state law. That may or may not be what you want. It's especially difficult for mixed families because in mixed families, it's going to give your spouse probably the first $250,000, and then the rest of it they've got to share with the kids that aren't theirs. So 50% of it goes to your kids just regardless. Will your spouse be able to live on just half of what you own for the rest of their lives? That's something to really think about. And when it comes down to your home gets really complicated. They may not get ownership at all depending on the age and how it goes. They may get what's called a life estate, the right to live there, not really to own it and sell it depending on how things go. It's definitely something to keep in mind. And incapacity, when you have nothing, we've got that same court cost. We've got a living probate on top of it. We've already talked about. Now, joint ownership, okay? The surviving joint owner gets full ownership. So most of us have our house joint with our spouse. We die, our spouse just files a document with a death certificate, and boom, they've got the house. It's like putting a beneficiary on there. But it can be more complicated than you think. Let's kind of look at how that goes. If Tom and Ann, let's talk about their house. They own it jointly. Tom dies, Ann inherits it. Ann dies now because there's no joint extra owner. If she's got a will or she didn't do anything to avoid probate, there's going to be a probate, and then Ann's heirs will get the probate. Notice we didn't say Tom's heirs, it's Ann's heirs. Ann gets to decide where that house goes. Let's look at something a little bit more complicated with it. Tom died. Ann got the house. Ann married again. She married Dan. Like most married couples do, when she married Dan, she put Dan on as a joint owner. Now, when Ann dies, where does it go? It goes to Dan. Dan better really love Tom and Ann's kids, especially if he has other kids and things out there, because he has to specifically now decide to be nice to them in his will. So by just going through that joint ownership, when Ann remarried, there's a decent chance that Tom and Ann's kids will be disinherited if Ann dies before Dan. So summary of joint ownership, it only postpones probate, right? It stops probate on that first death. When that second one dies, if there's no other joint owner, we've got probate. You can unintentionally disinherit your kids, because if your spouse remarries and it just transfers over to this person now who has no blood relation to your children, no blood relation to your heirs, they barely really like them, or maybe they won't leave them any of the money. And in incapacity, it doesn't do anything for it. The court's still going to come in and take care of that other spouse's half, and we're still going to have that be a part of the probate estate for the living probate. And it's very difficult to remove a co-owner. If one owner wants to sell, I mean, think about this. We're not talking about just husbands and wife. Maybe you own something joint with your sister. Maybe it's the house that was left down to you and your sister jointly from your parents. You can't really kick those people out. They either have to agree to sell to you, or you have to sell the house. Both of you sell it. There's no way to really have one person just take it and maintain it if the other one doesn't. If your sister decides, I want to sell this house and you want to keep it, it's going to get sold. Okay? If you can't buy it for the price they want, it's going to get sold. You lose that little kind of control. And lawsuits are pretty interesting, because if one person gets sued, then their half of that house, their half of that farm is at risk. It doesn't put any kind of protection for things like that while you're alive. Lawsuits can also mean divorce. If you leave it to your kids that way and one person gets divorced, it's going to kind of get lost. One person has a car accident and gets sued, it could get lost. What about taxes or debt problems? If they have debts and their creditors come in, or one half goes bankrupt, like say one spouse goes bankrupt, it could risk the house. Same thing for your taxes. Now let's look at the fourth type, just giving your assets away. You see this pretty common. I put my daughter's name on my house. I put my daughter's name on my bank account. I put my son's name on my bank account. These are gifts. You're giving away control. They're now part owners too. They have a say. And why is that important? Because remember, what if you give that to your son and then your son gets divorced? That half of that house or that bank account now is there for the divorce court to hand out. What if he has a car accident and gets sued? It's that same part, because you've given pieces of it away, and you may have intended for them to take care of you and use it to take care of you, but it's really not yours anymore. There are better ways to do it. Plus, there are some tax consequences. Let's look at kind of how this goes. Now, this may be more complicated than what you're used to, but we're talking about tax basis. Okay? If you buy a piece of property for $50,000, your basis is $50,000. We all know if we sell that for more than $50,000, there's some taxes that go in there called capital gains. Let's look at this. Let's say that during your lifetime, you buy a house for $100,000. You sell for $350,000. There's a $250,000 gain in there. There may be some tax breaks you can do, but if there's not, you're probably going to pay about $50,000 in capital gains tax under the current rates. Maybe more, maybe less. You never know how those things kind of go. Laws change all the time. Let's look at what happens when you pass away. If instead of giving it during your lifetime, you wait till you die, when we die, the capital gains inside an asset are wiped clean. Okay? If you die and it's worth $350,000 and your kids sell it for $350,000, there's no tax. If you give it to them, then they're going to pay the same tax you would have paid. So you could be 72, give your house to your son, die at 75. All those taxes are in there, where if you just would have held it for 3 more years when you passed, your son or your daughter could have got it tax-free. The fifth type of plan is your beneficiary designation. Now, this is a common way to avoid probate. Probate's pretty easy. We can put a beneficiary designation now on our cars even. You go down to the DMV if you're brave enough to try to get a new title, because you know how that's going now. You could put a transfer on death on there so that even your car won't need probate. There's a transfer on death deed to put on your house. You got to pay on death in your bank account. Your stocks and your bonds, they all have beneficiaries. Avoiding probate is easy, but it doesn't solve these other problems. What happens if your beneficiary is incapacitated? You know, you never change this. We leave them there for 30 years. We're going to leave it to our spouse. What if our spouse now is in the home? Now we've given it over to that living probate court. What if your beneficiary was your husband, but he died before you, and you never changed it then when you die? That complicates things then. Where does it go? Probably back into somebody's probate. If your beneficiary is my estate, you're choosing probate. You just are. If it's your kids, say you put our spouse and then our children, even when we're younger, then you and your wife are in the same car, you and your husband in the same car, and you both die. Your children survive you. Now it's all going to these minor children, right? And we still got that custodian, that court involvement. So they're useful for avoiding probate, but they may not solve these other problems. Now let's look at a revocable living trust. They're not for everybody. Some people it's going to be fine to do a will. Some people they're fine with risking probate and all that entails. But living trust gives you a little bit more control. They've been used for hundreds of years, just like wills. We name somebody to handle financial affairs. That's like that trustee. You name who you want to get your assets after you die. Absolutely. Wills don't avoid probate, though. Why? You're choosing probate with them. They're only effective on death. Living trust, though, it avoids probate. The trust owns it, not you when you die. So when you die, since the trust owns it, it doesn't have an owner who's gone. No need for probate. Living probate, your trust owned it, not you. So if you can't take care of yourself, that family member that comes as the trustee now can take care of you. There's no reason to start that probate. You have nothing left really to protect in that. It's inside the trust. Now, you do have to fund your living trust, right? Don't have anything in the trust, it doesn't do any good, right? If you, instead of, before when we had our will and things, we were taking all these assets here and put them in the probate funnel. We had fees and things like that. Well, think of your trust as just a different funnel. We put it into that funnel, but this funnel doesn't need those probate fees, okay? There might be taxes and things. There are some things that come along with that. We can't get rid of everything, but without those probate fees, and because those trusts help us handle taxes better, a lot more usually goes out to our beneficiaries. So you keep control. You can buy and sell assets the same as before. You can put things in your trust, pull them out of your trust. You can do all those kinds of things. You can change it any time if you change your mind, just like a will. You can go change where it goes to. You can change who your trustee is going to be. You can just rip it up and throw it away if you want to, just like a will while you're living. When you die, it's different, but while you're alive, you can do all these things. Your trust contains your instructions just like your will, okay? Sometimes our will create trusts too, but the trust that you make while you're living, it has those same instructions, and it can follow out just like a will, and they can even be instructions for how to take care of you while you're living and need that care. You can give your trustee instructions about how to take care of you with that stuff too, whereas you can't do that with a will. So let's kind of look at how a trust kind of works, right? There's the grantor, also known as the settlor. That's you. You're creating a trust. Then the trustee is the person who manages what's inside the trust. That's usually going to be you while you're alive and don't need help. Now, let's say you need, either you die or maybe your mind starts to go and you need that help, okay? Someone else steps in and becomes the trustee. When you're incapacitated, maybe your kid comes in, maybe your spouse. They take over as trustee. When you die, that same person who would have been your executor takes over as the trustee. Didn't even need a court intervention. They take over, they have the assets, and now they can give the beneficiaries your assets when you die, or they can keep it inside the trust and manage it and take care of the wealth forever and make sure it grows and take care of people, because while it stays inside that trust, It's protected from lawsuits and bankruptcy and divorce. When it comes out of that, it's fair game again. You can have an individual as a trustee, or you can have a corporation. Those individuals, that may be good while you're alive and things, but if you have a large amount of money or some special kinds of assets, maybe you want a corporation. They're experienced. They're professional asset managers. They know how to manage these things. Maybe your family members know how to manage distributions or help people. Maybe they don't know how to manage money and invest it in stocks and bonds or invest in different business enterprises. These guys have that kind of experience. They're also government regulated. They carry the right insurance and bonding and things like that. And they're pretty reliable with it. And Minnesota, we have high tax rates. There's some chances that if you choose a trustee that's a corporation in another state, that maybe you can avoid some of those taxes. There are some special trusts in special states you might want to take advantage of. They're beyond the scope of this. But there are right times to use a corporate trustee and times when you don't. And just kind of keep that thing open. You don't have to just have your son or daughter if you think they're not ready for it. And you don't have to use a corporation if you think they can do it. You have options. They also can be objective, okay? If you've got some heirs who have some issues, you may need to have someone that can be viewed as fair, who's maybe not involved in those kind of things to make decisions. And that comes when you control that inheritance, okay? I mean, do you have anybody in your family who might look like this character? I know it's a little extreme, but kids and things sometimes aren't ready for this stuff. They haven't seen the life of stuff. If you give it to him all at once, what's he going to do with it? Is it going to help him, or is it going to hurt him? Is he going to find he has lots of different friends who want to spend his money? You can get out of it in installments at 35, at 40. Is he going to be any different at 35? What about 40? Is he potentially going to be getting divorced? Because we always talk about, if you keep it separate, it really can't go in divorce. People always mix it, okay? That's how we live. And divorce happens. And once it leaves that trust, it might not be protected. You can give them just the income. You can say, look, I left you $20 million, okay, and it's invested. You can just spend the 5% that earns every year. It could be 500 grand. You can spend just the 5% or the 3% that earns every year. Keep them like that. So that way you can keep. There's also some other things you want to do for it. What if your beneficiary has special needs and they're getting really good things from the county? Do you want your money to go to the county afterwards? If you put it in a trust, these trusts can have special needs provisions in there so that it doesn't go to the county when your special needs heir dies. It doesn't interrupt their benefits. They can still get all the help they need from all the county workers and things. It can be used to supplement what they're getting and what they're using. They can be working in the community, but benefits usually don't cover dental and things. It can help with that. It can help redo houses. It can help them go on vacations. It can help them go to family reunions. It can make their life better and enhance it in a way that benefits can't. But those specialty kinds of benefits and doctors and social workers only come if the kid doesn't have a lot of money. And the same thing comes with minors. You want to keep it in that trust so we don't have to have that court intervention, that court monitoring, that court custodian that's going to cost a lot every year. And it protects everybody from their creditors. No one can sue and get in. You can't go declare bankruptcy and take it out. What about predators? It's in that file. If people know they've got a lot of money, all of a sudden they've got lots of new friends and long lost cousins coming out of there. Everyone's saying, I've got this business deal for you. Keep it in that trust. Control what it can be invested in. At least then they have to have a conversation with that trustee, and that trustee can say, hey, do you really think this is a good idea? And if the trustee doesn't think it's a good idea and you wrote it that way, it won't come out. It'll stay protected. It'll be there when your loved one needs it. So a summary of a living trust, it's going to avoid probate at death. It prevents the court getting control of your assets and incapacity, kind of keep that living probate cost down. Maximum privacy. Nobody but you and your beneficiaries really have a right to know what's inside that trust. Okay? Everything else has a court file. There are sometimes ways they can get in there, but sometimes not. And when I say sometimes not, that means most of the time. Very few times are they going to get into that trust unless they're family or beneficiaries and get to look at it. The public won't get to see it unless someone challenges it or the court somehow gets jurisdiction, and that is very rare. So it gets your maximum privacy. And also it's that quick distribution, right? We don't have to go through this probate thing. It stays in the trust. You've passed away or something happens and the beneficiaries need it. They just call up the trustee and they say, hey, I need this money for this or that. Trustee looks and makes sure it's in accordance with your wishes and the things you said can be spent for, and a check can be cut. They don't have to go ask court's permission to get money. They don't have to go ask this custodian, who then the custodian goes and asks court's permission. The trustee's there and has that quick access. And you can keep those assets in trust for as long as you want. Some people do it for generations. That's how they're really wealthy, keep those going and really grow those out. And if you want to keep it protected from creditors and those things like that, it should probably stay in that trust the entire time. When your kids die, sure, they can send it to other trusts and things if you want. You know, you're not making it. You don't have to make a trust that lasts 1,000 years, though you could. But you should at least have it so that it probably stays in there as long as possible. If you want to have any, if you have any concern about divorce or creditors or things like that, if you have no concerns about that, do that outright. Do those step things. But a lot of us end up having concerns about that, especially when we have a significant amount of money left behind. And it prevents that unintentional disinheriting. Okay? When people die and things like that, it doesn't just automatically go into this new spouse's hands. It can stay in the family. It can take care of that new spouse. Then when they die, control that it goes back to your kids and their kids and have those things go, right? It's not this part where anyone loses control. It's losing control of it beyond taking care of your spouse and things that can cause that unintentional disinheriting. We can also reduce or eliminate your estate tax if you're married. We can make somebody else pay for it. We can do all kinds of things that go with that and keep those costs down and really preserve the wealth. Now, for your medical decisions, people have heard of living wills. A healthcare directive is basically Minnesota's version of that. We're going to take your living will, which says, you know, what you want to happen if you can't make decisions. Do you want to be on life support? Do you want to live at home? Do you want to donate your organs? All those things that you normally put in the living will are just put into a document that also gives someone the power to make those decisions. Previously, in some states, there's a healthcare power of attorney. That person makes the decisions. Then you have this separate document called a living will that tells that person what your wishes are. Minnesota said, why do we need two pieces of documents? We're going to combine those, and it's going to be an advanced healthcare directive. And that's what you need for the medical decisions. We've talked previously about what you need for your financial things. Always remember there's this medical side of it you should really be thinking about when you do estate planning for that living probate or that take care of me in my when I can't voice my decisions kind of parts. There's also a HIPAA authorization. You fill this out all the time with the doctor. Who can doctor talk to and give information to? You think that trustee in your family and maybe even that person who's got the healthcare directive might need to know details from your doctors and things about your care to make those decisions? Absolutely. And it's not always a guarantee. There's all different kinds of bureaucracies. So you want to fill these out in these standard forms to hand to them so they know, hey, I can talk to this person, not, oh, let me go talk to my compliance department. Let me think how it's going to go. Sometimes we have to make those decisions quickly, and having this authorization handy can really cut through that and make those decisions happen quicker. But you got to do it now. You can't go sign these forms when you have a medical emergency. It's too late. You can't make that decision. So what should you do as your action plan from here? Write down your objectives, your goals, what you want, where you want it to go. Think about those things. Do you want these things to last forever? Do you want the family to work together and build that wealth? Do you want just to take care of the kids? Is there someone who has special needs or concerns, whether it's substance abuse or they need to be taken care of? Write those objectives down first. Take an inventory of your assets, not just what you own, but your debts and mortgages and things against it, so you can know what's left and what's there and what needs to be maintained. Then you need to go get a professional to help you. Of course, obviously, I'd be glad to help you because you're watching the video here, but you need to find an estate planning attorney who can help you. If you have a significant amount of wealth, you have one of those special problems like a bunch of rental properties or a special needs person and things like that, you need to go to a professional who has experience in those things. I do have experience in each of those. I'm a guardian conservator myself. I'm a special needs trustee, but you need to find someone who actually can handle that. Not every lawyer can actually has experience with those. Some people just have the dinner seminar and write 300 of the same trust every year, and they don't really get into these special kinds of things. So make sure you get the right person for the job. And then get your legal documents prepared. Even if you don't do a will or a trust, please, please, please get that power of attorney and that healthcare directive. Nothing scares a family more, nothing does more harm than something's happened to you, and instead of just taking care of you, they've now got to go into court, declare you incompetent, open these files and have those delays. At least get those 2 documents, okay? But beyond that, it's up to you to decide whether you want a will or a trust and how much control, how much privacy and things that you need. And you can't go without anything, right? If you want to go like Prince, you can go and just have the court do it afterwards. I mean, don't worry, it will get someplace. And lots of times it might even go where you thought you wanted it to be. But if you've got mixed families, or if you die young enough that your spouse could remarry, you got those extra problems. And then you want to change your titles and beneficiary designations. Go look up those beneficiaries. Pay on death. Are they who you want them to be? If they're not, put them on who you want them to be. If you make a trust or something like that, you better change the title and put it there. If you find out your house isn't joint, but you want it joint, you got to change the title. These are the things you got to do. Once you have a revocable living trust, you definitely need to change these titles and make sure things go into the trust if you go that route. If you want to go through a will, you better have those beneficiaries be the estate of. And that's the basics of understanding wills and trusts. I know you might still have some questions, especially the specific ones. You can always reach out to me. Go to reddenlawoffice.com, and you can call our phone number from there, or you can email me at info@reddenlawoffice.com. I'll be happy to answer your questions. But this probably gives you a good basic overview of what's there. It may seem overwhelming. Don't worry about it. Just start talking about it. Kind of get your wishes in line, and at least get that base estate plan in order. You're going to need to have a will or a revocable living trust, and you need to have that healthcare directive and power of attorney. At the very least, get that healthcare directive and power of attorney. You need it for your family. And if you'd like me to do it, you also can reach out at reddenlawoffice.com, and you can schedule an appointment right there. You can call the office. But I hope that you enjoyed it today. And if you have any other questions, just let me know.